Good morning. This is a special meeting of the Minnesota Board of Chiropractic Examiners being called to order on 20 November 2014 at 9:03 a.m. This meeting is being held in the Plaza Conference Room on the first floor of University Park Plaza, which is located at 2829 University Avenue Southeast, Minneapolis, Minnesota. The board is recording this proceeding both by video and audio. Therefore, for the purposes of voice recognition, I will ask each person seated at the table to identify themselves and their association with the board. Starting at my left.
Matthew Anderson, Vice President.
Mickey King, Board Staff.
Leroy Otto, Professional Member.
Greg Steele, Public Member.
Larry Spicer, Executive Director.
Howard Fiddler, Professional Member.
Teresa Marshall, Professional Member.
Robert Dotner, Professional Member and Administrative Officer.
Ralph Stouffer, Public Member and President. The recording in concert with the final report will constitute the official record of the board and will become public and available upon request once the entire proceedings are concluded. The board will set a time frame of 20 business days for the production of the report. Accordingly, I'd like to set the date for the next special meeting of the board as it pertains to the matter before us. The date for the next special board meeting is 16 December 2014 at 1 p.m. And I think, Mickey, you got a location finally?
Conference Room A.
Okay, conference room A.
Fourth floor.
Okay. The special meeting of the board is called to respond to the request by Senator John Marty for the resignation of the board's executive director, Dr. Larry Spicer. Senator Marty makes the request based on Dr. Spicer's response to Mr. Marty's inquiry into the board's handling of Paul Thompson's arrest for rape of a patient and the board's alleged failure to take adequate action against Dr. Thompson in 2007, which may have prevented the 2014 incident. This is a serious matter with potentially serious outcomes. Dr. Spicer is to be given an opportunity to respond completely and unimpeded to the questions set forth by the board. It is our duty to take all the time necessary to hear his responses to our questions, to deliberate on all matters before us, and to provide a complete and thorough report, concluding with our recommendations and actions. Good morning, Dr. Spicer.
Good morning.
How are you?
I'm fine, thank you.
You're in receipt of a letter dated October 15th, 2014, which outlines from Mickey King, which states the reasons for the meeting.
I am.
Okay. Dr. Spicer, the letter also stated you may elect to have this meeting opened or closed. What would you like to do with this meeting at this time?
I've elected to have the meeting closed.
Okay, thank you. Furthermore, Dr. Spicer, the letter stated that you have a right to be represented by legal counsel and a union representative. Dr. Spicer, what is your decision as it relates to the legal counsel and union representative?
I've elected not to have representation either by legal counsel or union representative, but I don't waive those rights.
Okay. Once the questions of the board have been answered by Dr. Spicer, the board will enter into deliberations and will go into executive session. At that time, all persons except board members, Mickey King, and would you kindly introduce?
I'd like to introduce Cindy Greenlaw Benton. Cindy Greenlaw Benton is the Human Resources Representative for the Administrative Services units for all the boards.
Okay. Good morning and welcome. When we go into executive session, I will ask Mickey King as board staff and the board members to stay along with you. During the deliberations, a consensus roll call will be taken to determine each board's position on the confidence or no confidence, whether the employment of Dr. Spicer should be terminated or continued, and what, if any, other recommendations and/or actions are to be made. From the consensus and the discussion, a final report with recommendations will be drafted and submitted to board members for review. A special meeting of the board will then be called to approve the final report, at which time a formal vote will be taken to receive, approve, and adopt the report. The vote on the report will constitute the decision of the board. The report and the decision will then be served upon the involved parties. The board has developed a series of questions, Dr. Spicer. The frame of reference for these questions has been the correspondence from Senator Marty dated August 27, 2014 and September 24th, 2014, and the correspondence from you dated September 2nd and other pertinent documents. I will be delivering the questions, and I pass this out. These are the questions, people. There's sort of an update from the ones we've developed before, but this is where I'll be asking them from. Dr. Spicer will be given an opportunity to respond to each individual question. After Dr. Spicer's answer, I will ask the members of the board if they have any follow-ups. And I will ask you to do this. I'm not trying to curtail you, but I'm the one that has to do the report on Thanksgiving while you're all eating. And so if you do a follow-up question, and let's say it's after question 5 on the list, I will ask you to write 5 on here in your question and pass it on either to Dr. Dashner or Dr. Anderson, so I can collect them at the end of the meeting and go from there. After Dr. Spicer has answered all the members' questions of the board, and if there are any follow-up questions, or if there are not any follow-up questions, we will state the next question and move on. After all the questions have been asked and given, and the answers given, the board will move into executive session. So with that in mind, unless there's any questions from anybody, we will start to ask the questions. Is that okay with everybody?
Yes.
Okay. First question is in 2 parts. So I'll ask them together, and you can break it up any way that you want to respond to it. Dr. Spicer, please give us a brief description of your professional background, career, and accomplishments. And the second part of the question is, Dr. Spicer, please provide us with a description of the licensee disciplinary history.
Certainly. With regard to my professional background, as we sit here today, I've been in healthcare for now about 45 years. And during that period of time, I have served as a practitioner, as an educator, as an author, as a matter of fact, authoring articles on subjects that are before us today. I've also been a regulator and a consultant. I started my career in 1969 as an electrographic technician. I was performing specialized tests such as echoencephalograms, electroencephalograms, vector cardiograms, things like that. I became a practical nurse in the state of California, and I worked in various fields then, including psychiatric nursing. I was a staff nurse at a boys' home for a couple of years, and I did geriatric nursing, and then eventually moved on to private duty nursing. In the private duty nursing, I managed such types of cases as cardiac cases, genital urinary cases, surgical rehabilitation cases, substance abuse cases, and psychiatric rehabilitation. During this period of time, I developed an interest in medical school. However, it was not really clear what I wanted to do with that. In fact, at this point in time, I became the president of the American Pre-Medical Association. But somehow the medical school didn't quite seem right to me, and I became somewhat disillusioned with it. And then I became a consultant to a major national hospital corporation and worked in the area of records management, records review with a nod toward revenue recovery. And during this period of time, I met a man who eventually became my closest friend. He was a doctor of chiropractic, and through him I began to learn what chiropractic was. I had really known nothing about the profession prior to this, but through my association and friendship with him, I gained an understanding of the profession. And he and I began to work on the building of a clinic, actually the design and the building of a clinic in Beverly Hills, California. This place sat as a dirt lot for 4 years while we worked on the designs for this building. And the building was going to be a large chiropractic clinic, which eventually was going to have 8 to 10 chiropractors working out of this clinic at the same time. And the plan was he needed an x-ray technician for this building. And so the plan was that I would go back to school and become an x-ray tech, which I did during this period of time. When the clinic, and I went to school and got certified as an x-ray tech, and then became an instructor at this school teaching x-ray radiation physics, radiation protection, positioning, and things like that. I eventually became the director of this school. In fact, this school, we eventually moved this school off to becoming accredited through ACETS, ACCETS, and my understanding, we got accredited on the first try, and my understanding that was kind of rare. But in my association with the school, and eventually we got the building built, and then I went into the building, the chiropractic clinic, to work as an x-ray tech, and seeing all the chiropractors working there and what chiropractic was doing, I decided, you know what, let's throw caution to the wind, and I went to chiropractic college. I decided to kind of step back a little bit. I continued teaching and I continued working at the clinic as an x-ray tech, but I went to school to become a chiropractor. I graduated from chiropractic college, excuse me, in 1985, and then entered practice there at Beverly Hills Chiropractic Center. While I was there, I was continuing to teach and to lecture in different places, and I was at one time lecturing in Omaha, Nebraska, where I met a beautiful woman. Eventually, you all know her. She became my wife. And because of that relationship, I moved to the state of Minnesota. I sold my practice in Beverly Hills, moved to the state of Minnesota, and became faculty at the college. I was on faculty at the college for a couple of years when this job became available, and I applied for it and was hired, and I have been here ever since. My faculty position at Northwestern was very much the same as my previous positions, in that my job was to teach radiation physics, protection, safety, and even some radiographic normals there as well. And I've been with this board since 1993. I feel a little awkward in discussing accomplishments, and so I knew that was coming, Dr. Stouffer, and I've sidestepped that a little bit by simply providing a letter to you, which I think sort of outlines the more important accomplishments I've had during this period of time, and so they're available for the record. But now, to your second question. Your second question was regarding a history of this particular case. You've asked for a brief history, but the history of this case is not very brief. I have provided sort of a summary for you. Ms. King has that summary. If you would, Ms. King, please pass that out to the board members, and I will go over it for the record, but at least you'll have something to reference while we talk. Paul Thompson was a chiropractor that was licensed in this state, and in the late 80s, roughly 1986 through 1989, Mr. Thompson, and I refer to him now as Mr. Thompson because he is no longer licensed, but Mr. Thompson was licensed. He was the subject of some complaints, essentially for improper touching and improper comments to patients. He denied those allegations at the time, and we had him therapeutically assessed. In other words, we sent him to a mental health professional for an assessment. The mental health professional assessment at that time indicated that Mr. Thompson was not at risk to act out as long as he was engaging in mental health therapy. And so the board entered into an order with him, in spite of his denials, we negotiated an order with him that was a 3-year, I believe it was a 3-year probationary order, during which time he could not, he first had to involve himself in the therapy that was recommended by the therapist. Then he also had to participate in his practice in such a manner that he could not be out of earshot of his staff under normal speaking conditions. So doors had to be open, or he had to be practicing in a manner where his staff could hear any normal conversation. And then a third condition was that he could not practice when there were no staff present. Mr. Thompson completed all the terms of that order and petitioned for an unrestricted license in 1995 and was granted that unrestricted license in 1995 because he had met all of the conditions of the order. Some 10 years later, roughly, we receive an additional complaint, a new complaint from another person, and I will just go on record as stating here that there were some fairly significant credibility issues with this particular complainant. Nevertheless, the allegations were close enough to the previous allegations that we again entered into negotiations with Mr. Thompson regarding these, and he again denied the allegations. However, he did agree to an order, and this one, now this was in calendar year 2005. And in calendar year 2005, we entered into an order with him that required, one, that he have a third-party presence at all time that he was treating or examining female patients or minor patients. He had to have a third party that participated had to sign the record indicating their presence during that treatment. We also required that he take an ethics and boundaries course. We required that he take the ethics and boundaries examination, which, by the way, was the old form of the National Board's ethics and boundaries examination, which has, as you know, had some reliability issues then. And we required that he continue his therapy. And during that time, we also received a report from the therapist indicating that he was benefiting from the therapy and that he was not at risk to patients as long as he continued to participate in this therapy. In 2007, remember that this was a 2-year probation from 2005. So in 2007, he petitions for reinstatement of an unconditional license. And as a result of that petition, we pulled some records from his office, reviewed those records, and determined at the time that there were records of treatment in which he did not have patient signatures. We automatically derived from that that there may have been times when he didn't have third party present during those patient treatments. However, he avers, he stated at the time that he always did have a third party present, and his staff member even supported that, which is something that I'll speak to a little bit later. Nevertheless, we did enter into an order with him. And the conditions of the order, now this was a modification. And by the way, let me just take one slight step back. The 2005 order established a condition where if there was a violation of the 2005 order, one of a couple things could happen. Either the board could suspend his license, or the board could extend the conditions and the period of probation or add other conditions. So in 2007, when we found these missing signatures, the board entered into an agreement with him for an amended order, and the amended order did in fact have a suspension of it, and the suspension was a 1-year suspension. 14 days of it was to be served, and the rest of it was to be stayed or held in abeyance. As you know, this is a situation that we have adopted over the years and used rather successfully, this stayed probation or stayed suspension approach, but it is something that resulted in some significant misunderstanding from Senator Marty and also from the victim's family. Putting that aside for a moment, we included all these additional conditions, including the suspension, partially stayed and partially served. That was part of the amended order of 2007. That probationary period was extended for 2 years. So in 2009, Mr. Thompson did petition for a reinstatement of an unconditional license. It was determined at that time that he had met all of the conditions of the amended order. And so as a result of that, the board did reinstate his unconditional license. And it's important to sort of emphasize this a bit. And that is that in 2009, he had met all the conditions, and as a result of meeting all those conditions, he now had an unrestricted license from 2009. So from 2009 to the events of 2014, 5 years or so, during that period of time, Mr. Thompson is operating with an unrestricted license. That's a standard procedure. The board and the public, of course the board knows, but the public has to understand that the board cannot impose limitless orders. In other words, orders that have no time limit on them. There has to be an end to orders. In his case, the end was 2009. So during those 5 years, he was under the same requirements as all other chiropractors licensed in the state. And then in 2005, of course, we have this horrible event that occurs in his office in late May or very early June of 2014. We get this report. I believe we get it from two sources. I think we got it from the newspaper source, but I believe that we also got it from law enforcement. Certainly our records can confirm that. That he had raped a patient in his office, and he admitted this conduct to the law enforcement officers. So on June 5th, simply a couple days later, the board entered into a temporary suspension with him under the provisions of the new temporary suspension law just established this year. And then 12 days later, the board issued an order of revocation with Mr. Thompson. That was very fast tracking in this particular case. Now, and that was June 12th. On August 7th, I was contacted by and met with a couple of representatives of the governor's office who, I'm sorry, on August 7th, well, actually shortly after that, there was then this article that came out in the Star Tribune, which was highly critical of the board's past interactions with Mr. Thompson. So on around August 7th, I met with these representatives from the governor's office who wanted to know more about what the board had done in the past. And then on or about, as Dr. Stouffer pointed out, we received a letter dated August 27th, the first letter from Senator Marty making essentially the same inquiries about the board's past interaction with Mr. Thompson. I took that letter and sent it around to the board members. I scanned it and sent it to the board members for their review and invited their comments, anything they wanted me to say in response to Senator Marty. I took those comments and drafted the letter, which eventually became my letter of September 2nd. But I drafted that letter and sent that letter around to the board members, also inviting review and comments and update, whatever. And following those comments and the integration of those comments, I then sent the letter to Senator Marty on September 2nd. On September 24th then, I received the follow-up letter from Senator Marty, which I believe that you've all had an opportunity to review. That letter was highly critical of my September 2nd letter, and that's the letter that called for my resignation. And that's essentially brings us here to today.
Any follow-up questions?
Okay. Dr. Spicer, if I understand correctly, with the 2007 petition for reinstatement, there have been no complaints from either patients or Mr. Thompson's staff about any inappropriate contact. It was merely through the records review that it was found to be a deficiency of signatures of observation. Am I understanding that correctly?
You are understanding that correctly, Dr. Dashner. In fact, there were no further patient complaints at all through that period of time. That 2007 amended order resulted exclusively from the fact that there were missing signatures. And I'd like to take just a step back on that for just a moment as well. When we inquired of Dr. Thompson why those signatures were missing, his statement was that there were two primary things contributing to that. One was that his office had become busier, and two, he had converted to a computer-based record-keeping system. So he was no longer writing his notes and then didn't have notes available right there necessarily for the third party to sign. What he did do in each of his notes was he did indicate in his computer record that so-and-so was present during this visit but he would not necessarily print those off right away for that third party to sign. But then to conclude, as you said, there were no further patient complaints, and there were no other indications other than that there were no parties, that there were no third parties present.
Thank you. And one additional, if I can. So in 2009, when he was granted an unconditional license, was there additional records review after the 2007 incident? Conditions were extended. Then in 2009, he petitioned and was granted an unconditional license. Was there additional record review, and if so, were any deficiencies identified during that process?
The short answers to your question are yes and no. Yes, there was additional records review conducted. No, there were no further deficiencies. Had there been further deficiencies, there probably would have been another order or some more serious outcome as a result.
Thank you.
Anybody else have a follow-up?
Just got a couple of thoughts, just for my own clarification here. Looking at Mr. Thompson's chronology here, back in 1991, it says it was recommended that he be allowed to continue practice, apparently by whoever was working with him. How do they know that he is? Well, I know you pass a test, you go through the ethics thing, or whatever it is. How do you know that the man is fixed, helped him, or a better person, or a better practitioner, or whatever, as a result of that?
I think I understand your question, Mr. Steele. You know, as a practical matter, we as doctors of chiropractic are not mental health professionals. We impose a certain reliance on mental health professionals to make these assessments and give us this information. Let me take one more step back and let's look at the actual conduct of Mr. Thompson at that time. The allegations were that he inappropriately touched and made inappropriate comments to patients. I believe that, if memory serves me correctly, the inappropriate comments would relate to their clothing or how they were dressed or something of that nature. And the inappropriate touch was hugging patients, which was a fairly common practice in those days. And also I believe there was one patient that he kissed on the cheek. There was kind of this side hug and he kisses his patient on the cheek. So he's assessed by the mental health professional, and he does have issues in his past, but the mental health professional did not believe that the conduct that was shown at that time, nor what was going on in his mental health history, would rise to the level of making him a danger to that public, and that certainly he needed some counseling, he needed some training, he needed to get a better understanding of these boundaries, but evidently the mental health professionals did not feel that he was dangerous.
The other question is 2005, you made a comment about questionable complainant. What was this questionable, why would you say that?
I'll be very honest with you. I probably went a step far in even making that comment because that's part of this area that is somewhat protected by the Data Practices Act. I just remember that the panel at the time had some questions about the credibility of this witness and the report that was being made. Nevertheless, we had the report, and it was close enough to the previous report. And remember, these things are online and they're public. So people can go online and read those, and then sometimes they make complaints themselves that are similar to complaints that have been received in the past about their licensee. Whether that happened here or not, I really don't know. I just remember that the panel was a little unsure about the quality of this particular witness.
Last thing I have a thought on is, Attorney General, our rep, is always at all of these meetings.
Yes.
Do we have notes on their support or of what decisions we made? I mean, I always question, they're at these meetings, and it seems to me that all the ones I've been at, we never had any issues with them. Well, we discussed our differences, but nothing of any serious consequence that they're on this side and we're over here. We can't meet, but surely they were involved in all of this, right?
Our Attorney General representatives are, as you know, sit in every complaint panel meeting. They come to our board meetings. They are involved in all the stages of our disciplinary matters, and this is particularly true because the process is much more detailed when we're talking about any kind of allegations that address sexual misconduct issues. A shorter answer to your question is yes, they're always there. Yes, they're always giving us advice. And I would say in all the years that I've been here, we nearly always follow their advice. We rarely have ever, can I remember where we've taken a position that is completely contradictory to their advice.
Dr. Marshall?
Dr. Spicer, I have a couple of questions. In regards to the 1991 complaint, were the complainants, were all of the complaints hugging, or were there any inappropriate touches of breasts or private parts, or?
I have to be honest, I don't remember. First of all, in the 1991 order, please understand, I was not here at the time.
Yeah.
I started in 1993. I do not believe that to have been the case in the later order, which came in 2005. But I don't have a detailed knowledge of what happened in the 86 through 89
So
issues.
that time period was 86 to 89. It came to light with the complaints in 91.
Correct.
Okay. Mine's a multi-faceted question. Was it staff and patients? Here in one,
I believe that it was.
1A1, it's the staff and employees or patients. So it was a time period 86 to 89. So there was a period of 3 years. And as the complaints didn't come in until 1991?
Dr. Marshall, I can't respond to that question honestly because I don't know the answer to it. I will share with you that most of the information I got regarding that particular order, I took right off of the order.
Okay.
It's the order that's posted on the website.
It just seems like such an extreme amount of time from 86 to 91 for a complaint to come through.
Well, as we know, as you know, as board members, very often conduct does go on for a period of time and then we get late reports on it later on.
Correct. I think that answered my questions. Thank you.
Anybody else?
Mine has been answered.
Okay. Question 2. Dr. Spicer, what was the intent and purpose of your letter dated September 2nd, 2014 to Senator Marty?
I would like to preface my answer by reminding you that for almost all of my life career, I've been an educator. So I proceed almost always from the intent to educate and to provide information for people. And in this particular case, in this letter of September 2nd, my intent was to do a couple of things. One was to educate the senator and to give him information about the board's functions, about the board's capabilities, and even about the board's limitations. And certainly, the intent of my letter was to respond to his inquiries. He's a senator. He's making inquiries on behalf of a constituent, and I wanted to give that information to him. I had a quiet sub-interest in which I created through this letter itself, which was to invite the senator to make this information available to the father and to the family who had never contacted the board. So essentially that was my intent.
Okay. Any follow-ups?
I do. Prior to this whole interaction with Dr. Marty, have you had any other interactions with him, and if so, to what extent?
To a rather minor extent. As you know, the boards every legislative session find their way to the legislature for various reasons. Every other year we're addressing budget, as we are this upcoming year. And so we have to go to committee meetings and we have to testify. Sometimes we have to provide education, which I've done a number of times to the legislature. I think as a short answer to your question, I have had interactions with Senator Marty, but they've been very distant kind of actions. There have been times when I believe I've testified on his committees. I have absolutely nothing that comes to memory or that boils to the top in terms of my interactions with Senator Marty.
Go ahead.
Dr. Spicer, so once your letter went out and the letter came, or his initial letter came back and the letter out, have there been any phone calls for yourself to Dr. Marty or Dr. Marty to you to...
Senator
Senator
okay.
Marty, I
Okay.
apologize, Senator Marty and yourself, or has everything been letters, via mail and via letters?
No. Yes, actually.
Okay.
Yes, there has been an interaction. It was clear to me after the letter, Senator Marty's letter of September 24th, my view was that there was a clear and outstanding misunderstanding of what my intentions were and what I was trying to convey in the letter. I got some advice, and I took that advice, which was to try to contact Senator Marty and give him an opportunity to ask any questions of me that he might have. And so I thought that was good advice. So I made contact. I actually called on the phone. I called his office, presuming that that a staff person of his would answer. And in fact, he answered the phone. So I talked with him directly, and I just said, Senator Marty, I think there's been a misunderstanding here, and I want to be sure that all of your questions are answered and that you understand what my intentions were. I would like to set up a meeting with you. He indicated to me at that time that the reason he answered the phone was because his staff had just stepped out. And he said, so my staff will be back in a few minutes. They have my calendar. They will call you back and set up an appointment. That didn't happen that day, and I came to work the next day and got an email directly from Senator Marty indicating that he felt that it would be inappropriate for us to meet. I followed up with that. I tried to make an appeal to him. I followed up with the email and said, I really want to give you the information that I think you're seeking and would really like to be sure all of your questions are answered, but I never heard from him again.
Anybody else? Dr. Spicer, I think you sort of answered this, but I'll ask it anyways. Dr. Spicer, Senator Marty stated that your letter attacks the father of the victim and questions the father's motives for contacting his elected representatives. How do you respond to that comment?
Well, first of all, in absolutely no way was my letter intended to attack the father of this victim. I certainly support any person's right to seek a redress of their grievances by contacting their public officials, including, in this case, the father first went to the press, and then he went to the governor's office, and then he went to Senator Marty. I was, however, just a little perplexed by this because the agency that the father seemed to have the problem with was the board. And I was simply wondering why, and confused about why the one agency that he seemed to have the problem with was the one agency he had never contacted to state what his issues or his concerns were. And so in the course of my letter, I was offering a musing, if you will, a kind of a query to Senator Marty, wondering if maybe somehow, wondering why this father had not made this contact, and I believe that to be a legitimate question at the time. I was wondering what the father really wanted. I was trying to discern, did he want a different outcome? Did he think that the board should have had some different processes or procedures? And in fact, if I look at Senator Marty's first letter, Senator Marty's first letter says, in the very last paragraph, he asks, finally, Is there anything that the board can do to let the victims of this tragic situation see that the board understands their pain and will spare no effort to prevent a similar mistake from occurring again? The short answer is no. If this person never makes contact with us, there's no way we can let them know that we understand their pain or let them know what it is that we're trying to do to make things better. So I merely pointed out to the senator that the board couldn't be helpful to this person if we didn't have interaction with this person. It was not in any way intended to be combative. In fact, I felt great empathy for what this man was going through. I certainly know what would happen if something happened to, like we all know what would happen, how we would feel if something happened to one of our children. So, and that was, by the way, part of the reason why I invited the senator to provide my response to the father, because it occurred to me if he was not going to contact us, he being the father, that this may be the only conduit of information that comes from the board to the father.
Any follow-up? Dr. Marshall?
Dr. Spicer, is it your understanding that the first contact the father of the victim with our board was at our last board meeting on 11/6/2014, or were there previous contacts with the board from the father of the victim?
No, the first time we had contact with the father was at that board meeting, and most of you were there. The father appeared at our board meeting and provided for us a witness statement, a witness impact statement that had been submitted by, I'm assuming it was his other daughter, the sister of the victim. A witness impact statement that had been provided to the judge in the criminal case. And this poor man showed up at our meeting and wanted to give that to the board so that the board had a sense of what was going on. Now, interestingly enough, that was a very short meeting, perhaps a divine intervention. And it allowed me to be able to go to this man at the end of the meeting and ask him, can we sit for a minute, can we talk? And he agreed. And so we came back to the board office and talked for about 45 minutes. And that was a really interesting conversation, because I would like to share some things from that conversation perhaps a little bit later, but I think it gave an opportunity for the first time for both of us to put a face on the other side of the aisle, so to speak, and I gave him a chance to be heard. I mean, I heard everything he had to say, and frankly, I agreed with most of what he had to say. I think that he had really good points. But no, that was the only time we've met.
Anybody else? Dr. Spicer, in his letter to the board, Senator Marty believes that the, quote, tone of the letter failed to grasp the depth of the anger and frustration felt by the victim of the sexual harassment and her family, end the quote. Senator Marty characterized your footnote regarding the process in which the family may have felt dismissed as combative, quote unquote, and further characterized as tone deaf, quote unquote. How do you respond to those statements?
Well, first of all, my September 2nd letter was in absolutely no way intended to be combative. Those board members that are here that have worked with me for the years know that this is simply not my style. I'm not a combative person. There was an unusual process that occurred here, and again, perhaps this was my mistake in crafting the letter. But again, I was offering a musing to the senator as to why events unfolded the way they did. As board members know, anytime we receive a complaint that has even the slightest hint of sexual misconduct, they have to go for investigation. So we refer them to the Attorney General's office on a special form and request an investigation. Then that's followed by that goes to the investigative division of the Attorney General's office, and then that is That starts the investigative process, and that most commonly results in an interview between the investigator, which would appear as the board's representative in the case, the interviewer, and the victim. This interview then gives the victim an opportunity to express their pain, their anger, their frustration, to vent whatever it is, whatever emotional issues are going on with them that resulted from this conduct of the licensee. It may even give them an opportunity to state what they feel should be an appropriate outcome. This was an extremely expedited case. It occurred this way because Mr. Thompson made admissions. That allowed us to pass up a whole bunch of processes. And as I stated earlier in the chronology, that within days he was revoked. His license was permanently revoked. And so as a result of that, there was no meeting between the investigative division and the victim themselves. And so there was no contact between the board, so to speak, and the victim, or the board, or the victim's family, which may or may not have been interviewed anyway. However, I was then musing in this letter, I wonder if, because this happened in this manner, is it possible that the victim felt dismissed or divorced from any of the board proceedings, or not considered as part of this event, that it just happened so fast they weren't even part of it. And I think from that the senator just misconstrued what I was trying to question.
Okay, thank you. Any follow-up? Okay, I'll go on to the next question then. Dr. Spicer, per Senator Marty's letter, he believes that the board does not understand its mission or purpose due to the lack of leadership from the executive director. As executive director, have you failed to educate the members of the board as to the board's mission or purpose?
In my view, I think this derives from a lack of understanding of the various roles of the board members and the executive director. The role of leadership is actually vested in the board through the development of policy. The executive director is an administrator of the board's policies. Now, it is true that the mantle of leadership often falls to the executive director. However, that leadership is in fairly confined roles with regard to the leadership question. For example, it's the executive director's job to provide leadership to the administrative staff. It's the executive director's job to provide leadership in implementing the board's policies. It's the position of the director to steer the board away from policies which may be contrary to state policy or to state law or what have you. It's the director's leadership role to make sure that the board remains compliant with state fiscal policies. It's the director's role to provide some training to the board members regarding their roles as board members. And finally, it's the director's role to provide information to the board in as neutral a fashion as possible so that the board members can conduct their business. With regard to the second part of the question of failing to educate the board members, I simply disagree with this. Every board member that is here, at the beginning of their role as a board member, went through an orientation with me, and part of that orientation is designed to teach the board members about their roles of public protection and to separate that, particularly with regard to the roles of the licensee members, and to separate that from their role as a practicing doctor of chiropractic. Finally, I believe that I have regularly supported and worked hard to support the role of the public members, which have a unique role with the board, to assure that the board always pays attention and focuses its activities on its limited role of public protection. You know, when we have meetings, and we have complaint panel meetings in particular, I believe it's part of my role to keep the board members mindful of their role of public protection. However, here's the reality. I never have to do that. And the reason I never have to do that is because I believe the board members know their own roles so well that I find what often happens in complaint panel meetings is the board members are reminding each other of their roles. They're asking each other, how does this decision that we're making or this discussion that we're having, how does this serve the public protection? So in my opinion, the board members know their roles extremely well, and I don't even need to continue playing a role in that because they do it themselves.
Any follow-up? I hope you're writing all these questions down.
I am.
Okay.
Dr. Spicer, so in the complaint panel process, after you've got a new board member in and you've gone through the orientation, let's put ourselves in a complaint panel process. It's traditionally a member of the Attorney General's office, 2 board members, and yourself. Do you have a vote in the process for the record? Do you have a vote in the outcome of a complaint panel process? Or is your role more of answering questions that would be pertinent, pulling statute out, and guiding the board members on maybe some of the things that they wouldn't be as up to date on as you would? What is your role in that complaint panel process? Do you have a vote?
The short answer to your question is no. The executive directors are prohibited, staff actually are prohibited from having a voting function by statute in the complaint panel process. My role, which I believe you outlined some of, is primarily to compile and present information to the board members to make sure that they have whatever investigative reports are necessary to provide information regarding the statutes or the laws, and which is also supported by the sitting Attorney General representative that's there. And then finally, in those rare occasions in which the board may be moving in a direction that may be contrary to state policy or to state law, my role is to advise them of that. I try really hard when a complaint panel is convened, and particularly when we're having a meeting with a licensee. Once we go through the sort of question and answer period with the licensees, I try then very hard, actually, I kind of physically push my chair back and call the 2 board members to engage with each other for these discussions, and then I try to stay a little lower key in that discussion. And that's just the way that I've tried to play my role.
Thank you, Dr. Spicer.
Anybody else? My learned colleagues on each side of me reminded me that I skipped a question. So I got to go back up to number 5. Dr. Spicer, Senator Marty stated that you, quote, lack an understanding of the ongoing pain and experienced by the victims and their families, end the quote. How do you respond to this comment?
Well, at the risk of sounding arrogant, I believe that I've become highly regarded both on a state and a national basis for my level of knowledge regarding issues related to sexual misconduct by licensees. I believe that I've also become well regarded for my regulatory acumen. In earlier years, I used to go around the country on behalf of this board. I used to go around the country teaching the issue of sexual misconduct by professionals and professional boundaries. In fact, in one state, in the state of Oklahoma, one year, my name was actually written into an administrative rule as the only person qualified to teach that subject matter to their licensees for that year for the purposes of continuing education. I have been published on this subject. I have been referenced by other authors on this subject matter. I have file cabinets at home that are full of reference and research materials on the subjects of professional boundaries and professional misconduct by licensees. I have made numerous presentations even to the legislature over the years on this subject matter. I have presided over cases in which marriages were broken, licenses were lost, families were damaged, and I have presided over cases in which people have lost their jobs because of the conduct of their employer, one such case here. I have presided over cases in which victims have considered suicide because of this type of misconduct. I've come recently to find out that this was one such case. And I presided over cases in which doctors of chiropractic have successfully committed suicide because of their misconduct. So I disagree with that viewpoint. And in fact, I would go so far as to say that my knowledge of this subject matter probably far exceeds most legislators in this case.
Okay. Thank you. Any follow-up?
September 2nd letter, it seemed that this was overlooked or kind of not addressed in the subsequent letter from Senator Marty, which I'm on page 2, the fourth paragraph, and it's one of these, a couple sentences which states, begin with, under no circumstances does the board condone or in any way support the action. The board is truly embarrassed by such an unexpected and unanticipated series of events. I realize the letter's in there, but it seems that the senator's letter didn't acknowledge that statement, so I wanted to read it into the record.
Okay. Anybody else have follow-ups or statement? All right, in that case, I think I'm on track here. Number 7. Dr. Spicer, Senator Marty stated that you show a great concern for the, I can't pronounce that, a great concern for quote-unquote property rights, and that the board would have been unquestionable legal grounds to pursue enforcement of the probationary, thank you, conditions the board imposed on for patient safety. How do you respond to this, if you can understand what I just said?
Well, thankfully, you've also written the questions out. So I see really that there are 2 questions here, and so I will try to respond to 2 questions. And to the first part of the question, I would also respond on 2 levels. First of all, I am an American citizen, and I'm a strong believer in everybody's constitutional rights. I tried to educate the senator in order to explain the parameters within which the board must operate. It's my view that the senator misconstrued this part of the letter, and certainly misconstrued the intention of this portion of the letter. As an officer of the state, my obligation is to protect the public, but it is also to protect the constitutional rights of everybody that we deal with. We are duty bound. We as a board, you as a board, and me as the executive director are duty bound to protect these rights. And our failure to do so can have severe consequences. First of all, our failure to do so is an abridgment of the state's duties and the board's duties and its obligations. Failure to do so, failure to protect the constitutional rights of the licensee can effectively cause significant harm to the board and to the state. Failure to protect the constitutional rights of the licensee can cause the board to engage in what is often referred to as a reversible error, which then causes great harm to the respondent. And let me tell you what happens there. The board fails to protect the constitutional rights of the licensee and then imposes an action on this licensee. The licensee then goes to the state appeals court. The appeals court will very likely overturn the decision of the board because of the technical error or the failure to engage the constitutional rights of that person. What happens then? The licensee may very well be returned to practice. Now you've just returned that person to the public. thus imposing potential harm to the public because of your reversible error, your failure to protect that licensee's rights. So let me be clear about this. Anybody, in my personal view, as long as I'm here, anybody that crosses the threshold upstairs is going to have their constitutional rights protected, whether or not I find them or their conduct reprehensible. That's not the issue. And I make no apologies for this viewpoint. I would hope that if the senator were arrested for something, that the prosecuting attorney would protect the senator's constitutional rights with the same fervor that we protect the rights of our licensees, even if we find the licensee's conduct reprehensible. To the second question, the senator references my comment that the board would have been on questionable legal grounds, and at this point, to pursue action. And at this point, I was talking about what happened in the amended order of 2007. On this point, I'm actually a little bit confused. If we look at Senator Marty's first letter, I'm sorry. Senator Marty's first letter, and it's about the second paragraph.
What's the date of that letter?
I'm sorry, the first letter is the August 27th, 2014 letter.
Thank you.
He says in the second paragraph, he said, the Board of Chiropractic Examiners has an obligation to protect the public interest. This is what's important, though. He goes on to say, that does not mean it should immediately revoke the license of any professional based on the allegations of that professional. So he restates the board's obligation to protect the public, but says, however, based on an allegation, you should just not go out and revoke that person's license. However, all we had were allegations at that point. That was the only thing that we had. And we also had little or no supporting evidence for those allegations. The only thing that we had in some of those cases were the missing signatures. Nevertheless, in 2007, we imposed an additional substantial sanction. Remember that amended order included a year's suspension, partially served, partially stayed, additional probation, additional counseling, more continuing education, more examination. It was actually a rather substantial order for the outcome, as an outcome for simply the missing of a few signatures. So therefore, it's unclear to me what the senator would have considered should have been done, because when you look at that package that was imposed in 2007, really all that's left is revocation. That's sort of the next step. So he says on the one hand we shouldn't revoke, but on the other hand, all this other stuff that we did was not good enough. There's not really much in between those two pieces. So I'm a little bit confused about what he would have expected. In any event, in my experience, and with all the years that I have been with this board, I've been through a number of contested case hearings. I've had an opportunity to experience a lot of judges, to see how these judges act, to see how they write their reports, to see what kinds of things they find important. I believe, honestly, if we had taken this case, if Mr. Thompson had not agreed to an amended order, and we had taken this case to the Office of Administrative Hearings, I really believe that the judge would have come back with a lesser penalty than what we imposed through our negotiated order. Because all that was there was some missing signatures and no further patient complaints and no further indication of patient harm. So I have seen judges write reports like this saying, yeah, perhaps some level of discipline is indicated, but revocation would not rise to the level of a revocation. And so I think that the board would have spent a considerable amount of money. These contested cases, as you know, can run upwards of $100,000 or more. I think we would have spent a considerable amount of money and gotten probably a lesser outcome. And that money, those resources, would have been taken away from more emergent cases at the time. So my experience was, and my belief was, it would really not have survived OAH. And that's what I was trying to point out. And again, I remind you that this started, as Dr. Marshall pointed out earlier, or I believe as Mr. Steele addressed earlier, this started off with originally with a complaint from a witness that was not very strong. We would never have been able to take that witness to OAH. Was there a third part?
No, I don't think there was, unless you can interpret a third.
Oh, there was a third part. I'm sorry. Finally, the senator indicates in that we failed to enforce the probationary conditions of the order. Well, that's what the 2007 amended order was. If you look at, again, at Senator Marty's letter, the first page of his letter, down towards the next to the last paragraph there, he says that now several years later, when one of the patients was sexually assaulted during a clinical visit, we see the consequence of I think he meant consequences. We see the consequences of the board's failure to enforce the board's own probationary requirements. In fact, we did enforce the probationary requirements. Remember, the 2005 order gave us two options: to either revoke the license or to extend to suspend the license or to extend the probationary conditions. We did both. That's what the amended order of 2007 was. Further, and I think more troubling, is that the senator implies that had we done something different in the 2007 event, had we done something different, the events of 2014 would not have happened. He's trying to draw a straight line between what happened in 2007, the missing signatures, and the fact that this man 5 or 7 years later rapes a patient. I find it simply impossible to draw that line. Those two levels of conduct just don't relate to each other. I think that the additional things that occurred in the 2007 order was a more than reasonable outcome, and I remind the board once again that he then met all of the conditions of that order, had no further patient complaints, was granted an unrestricted license, and for 5 years existed on that unrestricted license. And that's when the conduct occurred.
I'll go to question 8, which you may have already alluded to a little bit. Dr. Spicer, Senator Marty stated that neither, quote, office busyness nor a new computer system is an excuse for failing to document an essential safety procedure. End of quote. This was referenced in your comment as to why the respondent in this matter failed to maintain third-party signatures. Were you trying to excuse the respondent's failure to comply with a provision of the order?
Dr. Stolfer, let's remember that I was responding to an inquiry by the senator. I'm trying to provide an answer in response, and there is a distinction between providing an explanation and providing an excuse. I was trying to provide an explanation, and I was not in any way trying to excuse this person's conduct. In fact, there was no excuse. These are not valid excuses for his particular conduct. And moreover, the violation was not excused. Again, he was a subject of an amended order in 2007. However, I was trying to point out in my letter sort of the realities of life. And the realities of life is that we are human beings, and human beings make mistakes. And people that are running offices make mistakes. Make errors. There is no office that I couldn't go into that within 10 minutes I couldn't find an error somewhere in that office. That's just the reality. Now, he made errors in an area that should be the result of heightened scrutiny. Yes, I understand that, but that doesn't mean that making these errors is impossible. There are, for example, multiple factual errors in the senator's first letter, probably resulting from the fact that he derived most of his information from a newspaper article. But the criticism of these errors, that they should have heightened diligence, I think is a valid criticism. But there was heightened diligence, and there was additional response, the 2007 amended order. But The board has to look at these errors when they occur, and it has to look at the intent of the error, and it has to look at the outcome of the error and whether or not there was additional patient harm, and then make reasonable decisions at that point. I believe that that's what the board did, and once again, he eventually met all the conditions of the order and was on an unrestricted license.
Okay, thank you. Any follow-up? Dr. Spicer, Senator Marty points out a concern regarding relying upon a statement of the respondent's employee due to a vested interest. How do you respond to this?
Well, I respond to this, first of all, the board realizes that certain witnesses can have a vested interest in the outcome. But I'd like to respond to this with a little bit of an anecdote. I was recently at the Minnesota State Appeals Court on a matter related to the board. Interestingly enough, on a case that had similarities to the case that we have under discussion today. And I would like to share with you, I believe that most people in this room have not been to appeals court before. It's a little bit of a different arena than a regular trial court. In an appeals court, what you have are, first of all, there's no more evidence that's entered into the record. All the evidence is entered there. All you have are two attorneys on either side of the question arguing their point of view. And sitting up on the bench, there is a panel of 3 justices. And in my experience going to appeals courts, very rarely does either one of the 2 attorneys, when they're starting to present their argument, get much past their second or third sentence when the justices start interacting with them and start tossing questions at them, and asking about these various issues. This was one such case. And in this particular case, part of this case rested on the fact that there was a statement made by one of the staff members of this particular doctor, and the staff person in this particular case happened to also be the doctor's wife. She was the staff person in the office. And the justices made significant statements about the fact that you cannot discount a person's statement, which is typically made, by the way, under some threat of penalty. You cannot simply discount someone's statement just because they have a vested interest. That the board has to give weight to these statements. Now, you can decide that the statement may not have credibility. That's fine, but that's a decision that you make. But you simply cannot just dismiss it out of hand. And so let's look at these 2 cases. In the case in front of the appeals court, all we had were the doctor's statement and the wife staff member's statement, but that was countered on the other side by 2 independent witness statements who had diametrically opposed stories. In this particular case, that was not the case. All that we had in this case was we had the doctor stating there was always a third-party presence. We had the doctor's staff person stating there was always a third-party presence. There was a notation in the record, albeit not signed, but there was a statement in each patient record that there was a third-party presence. And what's on the other side? Nothing. There's no witness statement contradicting this. There's no additional complaints by any patient. So when you balance those out, you have to give reasonable weight to that doctor's statement, and the evidence to try to take a different viewpoint was very, very weak. And this is the evidence the senator felt we should have done something more aggressive on, and yet we did. We had the 2007 order. That was pretty aggressive for the level of evidence that we had.
Marshall.
Dr. Spicer, could you explain to me, is it the experience that you have of the board that if there is a third party present that has to sign off on the notes or be a witness, that they have to be shown the order and understand the reason why they are to be there in the room witnessing the treatment? Could you explain that a little further?
I'm sorry, Dr. Marshall, I missed the very first part of your question. Were you asking me if it was my viewpoint that should happen?
Well,
or?
I think because of the concern of the vested interest, could you explain the process that must undergo? It's more than somebody just walking into a room, and because anybody could forge an issue. I mean, again, it's, but could you explain the process? It's my understanding that the order has to be shown to all the staff, any of the staff that would be present. Could you explain typically what's in it, and do you have knowledge of what was in this order? Was the staff supposed to have exposure to the order and understand why they were having to sign off or be present in the room as a third party?
There are several pieces to that question. Let me address it this way. Generally, the patient or the person who is the third party may not necessarily always be aware of why they're signing that record. And to be very honest with you, Dr. Marshall, that is somewhat of a negotiating point, because some people have suggested that the doctors be required to give the order to each patient or each patient's third-party representative so that they can see why they're signing. My intuition tells me we would never get a doctor to sign an order like that. It makes them far too exposed. However, I would like to save that subject for a future discussion with this board, some variation of that concept, which, by the way, derived from my conversation with Mr. Rihanna, the father of the victim. Putting that aside for a moment, yes, we do at times in certain orders require, as an element of the order, that all staff be given that order and sign an affidavit that they have read and acknowledge and understand the contents of that order. We also apply that to any associate doctors that may be working in the office, and we apply it to any third parties that may eventually come to work in the office, that within a certain period of time of starting their employment, they have to be shown this order and fill out an affidavit stating that they have read, sign, and understand the contents of this order. That is a provision that we have used in certain cases. It was not used in the case of Mr. Thompson in the first portion of the order, and that is in the 2005 order. However, I do believe that we required that in the second, that is in the amended order. Yes, I have indicated in your summary there that when we had the amended order, that he was required to make sure that all staff had read, staff and or associates, read, reviewed, understand, and acknowledged the conditions of the order. And so that was an additional requirement of that amended order.
Thank you.
Any other? Okay, I will move on then. Senator Spicer, well, we just got you elected. Senator Marty.
It's not a good idea.
Senator Marty states, quote, unless the board was able to contact each of the patients treated by Mr. Thompson during those years to confirm that there was an observer present in the room during the appointments, accepting Thompson's excuses was putting the patient at risk, end of quote. Dr. Spice, how do you respond to that statement, Senator?
Well, this may derive from the fact, from the belief, the errant belief that the board has unlimited resources. It simply does not. In order to do this, the board would have had to, through the investigative division of the Attorney General's office, the board would have had to have gone in, acquired a complete patient list of this doctor, and then sent interviewers out to interview every patient the doctor had. First of all, I don't think that's ever been done by any board. That is completely a fishing expedition, and not only that, but the amount of cost that would have been generated to do that would have probably run in $100,000 for that kind of investigative demand. So it's just not realistic. It would have been a budget buster, and that would have taken those resources away from more emergent cases that were going on at the time.
With no indication of follow-up, I'll move on to the next question. Senator Marty further states that he knows a number of male and female chiropractors and cannot picture any of them hugging a patient in 1991 or today. Dr. Spicer, how do you respond to that comment?
Well, first, I guess I would say that I'm glad the senator can't imagine that. That tells me that he hasn't had that experience. But I would actually like to go to Senator Marty's. I'd like to flesh that comment out just a little bit from Senator Marty's letter. On page, and I'm referencing his September 24th, 2014 letter, and I'm looking at the second paragraph. Actually, the end of the first paragraph. When he says, I know, as you just read, Dr. Stouffer, I know a number of male and female chiropractors and cannot picture any of them hugging a patient in 1991 or today. He goes on to say, even Dr. Spicer's statement that hugging patients is a practice which tends to be discouraged today is out of touch. I don't know why that's out of touch. I mean, it seems to me that's an important statement. We do try to discourage that conduct. But the last sentence in that paragraph is most telling. He says, can you show me a single chiropractor who believes it is appropriate to hug a client in the scope of their practice? That's the type of question that would make any defense attorney just cringe in pain, because he's asking a question to which he does not know the answer. I feel fairly confident that every chiropractor sitting at this table knows, especially in 1991, it was common practice to hug patients. And I believe that the chiropractors sitting at this table also know that it happens a great deal even today. As a practical matter, we know that this conduct occurs. We put on an annual seminar entitled Practice Issues, and one of the behaviors that we talk about every year at that seminar is it's a bad idea to hug your patients. Why? It's not illegal, but it is characterized as a risky behavior, a behavior that is going to confuse some patients and result in the submission of a complaint. How do I know this? Because we get the complaints and we deal the complaints. We just had a complaint that we dealt with just a few weeks ago, a new complaint on exactly that subject matter. So to conclude that this just doesn't happen just because you don't believe it happens, it just is not supportable. So I guess I have no more to add to that. It is something that we deal with regularly.
More of a statement than a follow-up question. You know, we're in a very touchy-feely profession. I mean, we work with our hands every day. Our hands are on patients. And I don't think there's a single chiropractor that's sitting at this table that hasn't adjusted somebody that we were either their last resort or that was in so much pain when they came in, that got up off that table, looked at us, and actually hugged us to thank us because we were their last resort. It happens. It happened in 1991. I dare say it still happens today. I just want that stated. That.
Okay. Anybody else? Thank you. Dr. Spicer, Senator Marty states that you trivialized a sexual assault on a patient that might have been prevented when you state, quote, and the final analysis is just that one bad outcome with approximately 60 successful ones. How do you respond to that statement, Dr. Spicer?
Well, Dr. Stouffer, I'd like to place this in context. First of all, in the 22 years that I've been here, what I was referencing is that we have dealt with approximately 60 cases with similar facts involved in the case, and that is to say, you know, some level of sexual conduct, and it can be all the way from the level of, you know, an improper touch or an improper comment, all the way to actual sexual intercourse, fully improper sexual conduct. And we have sort of developed over the years a package, a fairly consistent package of how we handle those particular cases. They often result in an order that has the requirement of a third-party presence, additional training, additional examination, you know, things like that. It becomes somewhat of a standard package. I would like to go to my letter, page 5 of my letter.
Hang ahead. We're talking about the September 2nd letter, correct?
Yes.
Page what?
Page 5, the last page.
I'm there.
Towards the end of the very first paragraph, the top paragraph there, I stated, however, the board does not have the luxury of allowing passion to overcome reason or prudence. There will never be a way to defend an unintended outcome, particularly to the victim of that outcome. But in the final analysis, in this case I was referencing, it is just that. This was one bad outcome against many more successful ones. Now, what I was saying by that, first of all, let me point out that the board is more than a licensing agency. These boards are more than just licensing agencies. They are also quasi-judicial agencies, and that means that they have to deliver their disciplinary, the disciplinary portion of their conduct very much like a criminal court would, in that they have to be fair and they have to be even-handed in the way they deliver their work. So the board has to consider all of the evidence that's before it and has to balance all of that evidence. Now, to answer your question, I have to approach it from 3 different points. First, as I pointed out a little earlier, the senator tries to draw a straight line between what happened in 2007 and even 1991, but then in 2005 and what happened in 2014. If a kid is busted for shoplifting, should we put that kid in jail because someday he might rob a bank? And that's really what we're talking about here. There's a journal, Psychology Today, that has written a number of times articles over the years on something referred to as the McDonald's triad. The McDonald's triad is a behavioral piece that has 3 elements to it that says they have found that people that engage in violent behavior in their adult life have these 3 elements. And one of the 3 elements is enuresis, or extended bedwetting into a later age. So does that mean that everybody that has extended bedwetting should be jailed just to prevent the possibility that someday they might engage in violent behavior? Well, of course, everybody sitting at this table can see the absurdity of that position. So therefore, I disagree that the events of 2014 could have been prevented by some action that we might have taken in 2005. That just doesn't make sense. I remind you that this licensee was not under order, had no restrictions on their license in 2014. He had met all of the elements of his order, and the termination of his order is even somewhat, or largely, supported by the state's own philosophy established under the Criminal Offenders Rehabilitation Act, which says you have to bring an end to all these people and give them an opportunity to reestablish that they have been rehabilitated and to re-enter the practice. And by the way, the Rehabilitation Act speaks greatly to professionals that have professional licenses, that in order to return to citizenship, they have to be given an opportunity to return and be complete as citizens once again. So and we add to that the fact that we had multiple psychological evaluations on this person that never predicted this behavior. So in short, there was no way to go from point A to point B and to make the assumption that in 2014 he's going to rape this patient. The second part of your question speaks to the trivializing of, you know, how I or the board may have trivialized this matter. And Dr. Dashner actually just read this paragraph. If you look at my letter is full of adjectives and statements. For example, characterizing this assault as reprehensible, I think contradicts the view that the board trivializes this matter. Characterizing or making the statement that the board is not only aware of the pain, but shares in this pain, contradicts the view that the board trivializes this matter. Characterizing this conduct as heinous conduct in this letter, I think, contradicts the view that the board trivializes this matter. Stating that the board shares in the stigma of this conduct contradicts the view that the board trivializes this matter. And making the statement in my letter that we understand, we recognize that this event resulted in substantial harm to the victim and to the victim's family contradicts the view that the board trivializes this matter. And finally, on government letterhead, this is a government document, me making the statement that the board members will pray for the emotional healing of this victim and this victim's family, I think completely contradicts the view that the board trivializes this matter. This was taken very seriously by this board, and this board took very swift action. Thirdly, the senator thinks that I'm trivializing this matter when I state that this was just one bad outcome in the case, in the face of 60 good outcomes. Personally, I think this comment stands on its own. When we have a body of experience that says we have used this procedure or this approach successfully 60 times, why would we suddenly assume that number 61 would go awry? That doesn't make any sense. Board members are appointed to bring their experience to the table. Now that experience starts off as experience as a doctor of chiropractic, but over time it is to evolve into your experience as a regulator. So your experience tells you, you know, we've done this 20 times, 30 times, 40 times. It keeps working. It keeps working in that you don't have these people that have done this coming back with repeat offenses. You are then obligated to use your experience of successful experiences and say, therefore, we should impose the same approach on this person. You know what? This one time, it didn't work. There's no way for you to predict that.
Okay. The next question I'm about to ask, you've sort of already answered, but it's in the same arena or province as the previous one, and along with your response. Senator Marty seems to contradict your view that there was no way to predict this respondent's behavior because experts say that sexually predatory behavior often accelerates. Can you respond to that, to the senator's statement?
Well, first of all, yeah, to begin with, the criteria. Well, let me say this. The very first time the word predatory ever came up was in Senator Marty's letter. Remember that we've had this man assessed by a mental health professional, I believe actually more than one, or at least more than one assessment. And the term predatory was never assigned to this man by the mental health professionals who have expertise in this area. The assignment or the tag of predatory has some very specific criteria that are used by mental health professionals to come to that conclusion. So there is nothing in this classification in this manner that was ever applied. In fact, the mental health professionals came back to us, or the mental health assessments came back and said, he is safe to practice. Yes, there should be some conditions, but given these conditions, he is safe to practice and to provide services. And so we required those conditions that the mental health professionals required. We required targeted continuing education. We required additional assessments. We required additional education. We established additional measures of security and protection. We imposed all of the measures that our experience in many previous cases told us should solve the problem. And once again, in this case, it didn't work. I think to have predicted the outcome in this case, that this patient would have been raped, would have been a challenge to the most psychically gifted.
Dr. Fiddler?
Dr. Spicer, 2 quick follow-ups. And again, even if the board had suspended Mr. Thompson for a year back in '07 without a stay, since part of it was stayed, would he still not have potentially gotten an unconditional license in 2009 or after?
It's very, I'm sorry, that was your question?
Yeah.
Okay. It's very highly likely that he would have come back within a couple of years and petitioned for reinstatement, and the board would have reinstated him, if for no other reason, based on the notion of the Criminal Offenders Rehabilitation Act. And by the way, he was not a criminal at this point.
Right.
It's just that that's a philosophical statement that the state uses.
And the follow-up, just once again, did any expert who examined Mr. Thompson ever conclude that his behavior was likely to escalate as it did?
No, absolutely not. In fact, they concluded quite the opposite. In fact, they were the ones saying he should be returned to practice under these conditions.
Thank you.
Dr. Marshall?
Dr. Spicer, when it is suggested by a complaint panel that a doctor licensee seek a mental health professional, does the board typically suggest certain mental health professionals, and do these professionals that do these evaluations have experience with doctors' predatory behavior or the type of behavior that we're concerned about for the board, or does the licensee get to just pick and choose and go wherever they want? Could you give us some direction?
That's a good question, Dr. Marshall. No, my staff person maintains a fairly substantial list of healthcare professionals, mental health care professionals that we have worked with over the years, and some of the other boards work with these same professionals, and we've sort of created a little community of professionals whom we trust to do good assessments, to provide quality reports, and reports upon which the board can rely to take its actions. We have those professionals divided into specific categories regarding their areas of expertise and where we have used them, and we even track the kinds of reports they've provided for us over the years. So that and every once in a while a new professional comes to us and we try them out. And sometimes we try that person out and we find, gee, their assessment wasn't that good, it wasn't that detailed, their analysis wasn't that deep, maybe we just won't use them for this in the future. Then, from this list, when we establish in an order a condition that they get an assessment, what we typically do is my staff sends them a letter and says, here is a list of 3 professionals, and those professionals are from that list. They may choose one of those 3 professionals, and then the assessment has to come from that professional. And we have established a relationship with that professional. So then release forms are transmitted back and forth, and the payment is arranged, and that kind of thing. So it's extremely rare. I would say it has happened, but extremely rare that a person gets to select their own professional. And that doesn't happen willy-nilly at all.
So there would be a record of experience for the mental health professional for evaluating somebody that would be a sexual predator. They would be directed to somebody that is experienced in trying to make those evaluations.
We typically, the people that we know about that do these assessments, there are names that I could put out that would be recognized by even sort of the common regulator, because these are people that have developed expertise in these areas.
Thank you.
Anybody else?
Dr. Steele.
Question. Whenever there's a charge or something made against the professional chiropractor, I guess I haven't experienced it anyway, that you get somebody report to the police or civil authorities. does that happen? Do we get a report from the police, whatever, on cases like this?
Typically, yes, and that's how this occurred as well. I think we got it from two sources, although I'm willing to stand to be corrected on this, but I believe that we got not only reported that was in the newspaper, but I believe that we also got a report from law enforcement. It is not uncommon, and it's not uncommon that the person that reports to the police will also report to us directly. Sometimes that happens. Sometimes the police just sort of let us know that something happened and then we have to dig into it. So there's several different scenarios, but yes, they're generally, they'll let us know what's going on if they know that the person's a chiropractor.
In a case like this where he's had some issues before, yeah, he admitted he raped his patient, but is there any kind of documentation on anybody even interviewing his staff for our own edification for future references? Because, I mean, obviously they said the staff member said he always had somebody at the observe his treatments, and do they find out more first that, hey, maybe a lot of these things were going on and they just haven't reported it?
Yes, but let's remember that those conditions ended in 2009, so he no longer had to have that third party.
Well, I thought somebody might have stated it just in 2014 as a result of this rape. Even though he admitted it, would they do a deeper investigation?
Not likely. I think, to be very honest with you, Mr. Steele, I think that the quality admissions were such that we didn't really need any more information. We just proceeded right to revocation, and that was good enough for us. So now, I will just point out to you, that has nothing to do with what law enforcement's investigations might be. I believe theirs were, they did conduct some investigation. I don't know to what degree that occurred. Excuse me. And I do know that he was convicted recently and is now in prison.
Anybody else?
Excuse me.
We are progressing along here. Senator Marty goes one step further and states, your vision is far short of 2020, and that you are unable or unwilling to look at improvements in this procedure. A true or false statement, or?
Well, I disagree with it. I think that derives from, I believe I may have used in the letter a statement, something to the effect of hindsight, hindsight has 20/20 vision, and he's tagging into that. But first of all, this has already become a significant part of institutional memory. I think that probably just about every board member sitting here on a panel who has a sexual misconduct case has at least talked about this case in the context or is juxtaposed with their current case. So this case is weaving its way through our institutional thinking. In addition to that, there have been conversations with the Attorney General's office regarding this case and future management. And certainly this case is and will continue to be discussed amongst my colleagues, the other executive directors in the boards, because these types of situations can affect most all of our boards. So moreover, when you suggest that the board is not willing to look, or I'm sorry, you're not suggesting this, the senator is suggesting that we're not willing to look at improvements, I would remind the board members that we are, that this is just not my experience with the board. We are deeply involved with the Federation of Chiropractic Licensing Boards. The Federation of Chiropractic Licensing Boards, the FCLB, is primarily, it is an association of all the licensing boards in the country as well as some from the international community. And their primary function, although some may want to add to this, but their primary function is to disseminate, distribute information back and forth. They are an information resource for all of the jurisdictions in the country. As a result of that resource, I'm constantly interacting with other executive directors and other board members across the country when we see issues of similarity. Well, how did you handle that in your state? What did you do that worked? What did you do that did not work? I very often have directors, executive directors from other states calling me saying, what is Minnesota doing in cases like this? Because we've become a resource for this kind of issue. So the very purpose of gaining that information is so that we can then apply it and make modifications and innovations in our approaches so that we can continually improve our approaches. I found this board to be highly flexible and open to innovation, and we've changed a lot over the years based on our learnings from, one, our experiences, and two, from the experiences of others through the Federation. Finally, as we talked about a little earlier, I had an opportunity to meet with the father, Mr. Rihanna. And in that conversation, I think that he made some interesting points that made me think a little bit. And though there are some things that he brought up, excuse me, that I would like to share in the future with the board, some future discussions about some additional innovations. I think that we can always grow and learn. And so I just simply disagree with that viewpoint.
Anybody? Okay. Senator Marty also states your attitudes are unwanted sexual conduct, send a message to victims that the head of the state licensing board views their situation as frivolous. Care to respond to that?
Well, this is a complete mischaracterization of my views and my intentions. This is not the message that I or this board are trying to put out there. In fact, I think the board tries to put out a much more aggressive message. In any communication, excuse me, I think my voice is getting tired. In any communication, there are two parts to that communication. There's the transmitter and there's the receiver. I, as a transmitter in this case, tried to do the best I could to put information out in a cogent manner. But there is a certain responsibility on the part of the receiver to try to receive it in the manner in which it's intended and not filter it through their own emotions or their own viewpoints. The message that I try to send on behalf of the board is that the board aggressively pursues cases of sexual misconduct, and that the board also, however, must acknowledge and comply with the constitutional protections of the respondent while we're doing that, and that the board's resources for complaints is somewhat limited, but it does the best that it can with those limited resources. And I tried to convey the message that the board, notwithstanding this particular event, that the board's outcomes in similar cases is very nearly 100% successful. So, I mean, that's the message that I try to send.
The next question you've sort of answered all along, but this is so you can give you an opportunity to sort of sum up. Senator Marty would like a response as to what policy or procedure changes the board is considering to ensure that this type of situation, where a license holder can ignore patient safety conditions with impunity, does not happen again. Would you care to reiterate? You've sort of done that all the way along.
Well, first of all, I would reject the notion that this licensee ignored these with impunity. He certainly had misinterpretations and misunderstandings as to how this was to be conducted. He made changes in his office that interfered with his processes. However, I would simply just repeat some of the things that I've already said before, which is that, you know, we will be discussing this with the Attorney General's office and other colleagues, and we'll be looking at different ways to see, are there other things that we can do to prevent this from happening again. So,
okay. Anybody else? In reviewing the senator's letters and looking at your reply, is there anything you would have done differently?
Yes, at least one thing. I guess I would just like to get this on the record. I read my letter back And I can certainly see how someone might come to this conclusion. I'm reviewing my letter on page 3, and it's where I was somewhat describing the history of Mr. Thompson at the time. And I spoke about the hugging of patients and that it's discouraged these days. And then I used the line, and kissing a patient, open parentheses, okay, there is no explanation for that. Exclamation point, close parentheses. I can see, if I sit back objectively and look at that, I can see how someone would see that as an attempt at levity. It was not meant as an attempt at levity. In fact, it was an attempt to make a declaratory statement. If it were said verbally, I would say, okay, there is no explanation for that whatsoever. That's how I would have stated it. But certainly that doesn't come across in the written word. It looks like levity. So I would have written that perhaps a little bit differently. However, having said that, I believe that in all other aspects, this letter is true and accurate. You know, truth is painful sometimes, but it is what it is. I stand by what I said in the letter. I could have used different verbiage, perhaps.
Anybody? At this time, Dr. Spicer, is there anything you would like to say in closing?
Yes. In the final analysis, this is an issue of employment. The board has been asked to end my career for making statements in the context of a letter. The board has been asked to end the career of a state and nationally recognized regulator for a single event. And what was that event? The writing of a letter. And the one letter, which in my view was subject to wholesale misunderstanding and misinterpretation. And in my view, this is a highly unbalanced response when you juxtapose the writing of the single letter with what I think has been a long and good career with a significant number of accomplishments. But I have considerable trust in the board. I have considerable trust in processes over time, and I know that the board engages these processes well. I get this image, when I think about the board sometimes, I get this image of like a sailing ship. You know, it's on calm and glassy seas one moment, and it's on treacherous and stormy seas the very next moment. One year, the legislature is criticizing these boards for being far too harsh on their licensees. And the next year, the same legislature is criticizing the same boards for being far too lenient. But we can't regulate by holding our finger to the wind. I mean, that's just not the way the boards can regulate. How can the boards regulate? They can regulate by using their experiences and their outcomes and try to reasonably navigate what are frankly pretty challenging political waters. The board's decisions can't be politically motivated. They can't be held to political incongruence. As most of you know, and some of you have experienced yourselves, my son just recently returned from 4 years of service in the Marine Corps, defending our constitutional rights. And one of those rights is the right to free speech. And free speech includes having an opinion. Well, you know what? You don't have to defend you don't have to defend popular opinions. That's not what that was written for. That constitutional piece was written to defend those people that have unpopular opinions, opinions with which you might not disagree. But it was meant to be protected. That's what we're protecting. And so I am perplexed that a senator who has been sworn to uphold the Constitution would threaten my livelihood and the livelihood of my family merely for the exercise of my constitutional rights and merely for the expression of an opinion which he finds disagreeable. Very honestly, I think if the senator found my opinion disagreeable, he should have done exactly that, disagree with it. Send a letter to the board saying, I think this is a bad opinion, I think it's a bad idea, maybe you should do some additional training, maybe you should do this, that, and the other. But I also think that the moment that the senator requested that you ask for my resignation, I think he stepped across the line at this point. If I had said something false, if I had lied, then the senator might have a different case. But that was not the case. What I said in the letter was truthful. And truth, in my view, is an absolute requirement. It's a prerequisite for wisdom. And I said, if you look at the last page of my letter, I said, we, meaning the board, we will continue to seek discernment in our deliberations and impart wisdom in our decisions. All of my life I have sought wisdom and discernment. You know, Confucius said, we come to wisdom by three paths. The first is by reflection, which is the noblest. The second is by imitation, which is the easiest. And the third is by experience, which is the bitterest. Certainly, everybody involved with this situation has been through a terribly bitter experience. The victim and the victim's family have been through the most bitter experience that one could imagine. And this is something that she's going to have to live with for the rest of her life. And in some ways, so will her family. The staff of this doctor have been through a bitter experience because through no conduct of their own, they lost their job because of the reprehensible conduct of their employer. And everybody sitting at this table has been through a bitter experience as well as we sit here today. But as I said a moment ago, in the final analysis, I still stand by everything I said in the letter, and I stand by everything that I was trying to convey in that letter. And what is it that I was trying to convey? I was trying to convey that these decisions are not made in a vacuum, that these decisions are not black and white, that they're very nuanced decisions. I was trying to convey that the board makes the best decisions that it can, that it puts out a tremendous amount of work and at significant sacrifice for a mere pittance, but that it does so with limited resources and it does so with great focus on public protection. I tried to convey that not all outcomes are perfect. I tried to convey that not all behavior can be predicted. And I tried to convey that not all harmful behavior can be prevented. And that in the final analysis, this was just one terrible but unpredictable event. So thank you for hearing me. If I have done anything to embarrass this board, I am sincerely regretful. I have nothing but admiration. It's been an honor and a privilege to serve with this board, and I would never have wanted to do anything to embarrass this board. So for that, I'm regretful.
On behalf of the board, we thank you. Let me give you some directions where we're going from here. We're about ready to go into executive session. Prior to going into executive session, I'm going to ask you a favor for me personally. I'm the one that has to write the report, which may not be too good, but we'll see what happens. If you have any notes from your testimony you'd be willing to share with me to help me ease that burden a little bit, I would greatly appreciate it.
Sure.
So I'll talk to you later about that. This is what's going to happen in executive session. We're going to ask you to leave. We're going to ask Ms. Greenlaw Benton to stay for the first part of it. We will not be deliberating with her in the room. What we will be doing is she has sat through this process for a specific purpose to look at it from that end, from her end. and to see what we need to keep in context with our deliberation. When we start our deliberation, I'm going to ask her to leave. So that's where we're at this point. So, for the purpose of conducting business related to a personnel matter, the board will now enter executive session at this time, and it is 11:03. Yes.
We take 5 minutes for that.
Oh, yeah, we're going to, as soon as we get into executive session. So at this point, I'll ask you to kindly leave, and the board members and Mickey are going to stay through, Ms. King are going to stay through the whole thing. Can you come up and do your little piece, and then we'll take a little quick break before we get into the deliberation.
Would you like me to pause the recording now or wait?
Oh, yeah, no, we're in executive session now, so pause the recording.
All right, recording is paused.
Thank you. The board has concluded the matter required to be heard in executive session. Therefore, the board is returning to its scheduled open meeting. The time is
11:45.
Thank you.
Yeah, 11:45.
I'll put 11:44 since I didn't hear that.
Should we then open the door?
Yeah, go ahead. Open the door. Before I get into the closing statement, I want to go on the record. First of all, I'd like to thank my colleagues for everything, because I kept throwing stuff at them, and they kept writing me back, and I kept throwing stuff. I appreciate all that support, and I really want to go out of my way to thank Mickey King. She was the firewall between Larry and I. She was sort of caught, and I mean this in a nice way, she was caught in the middle. Larry, she has to still do her office work, and Larry would say, we got to get this done, and this done, and then meanwhile I'm asking her to find out these answers and these questions, and then after I'd ask something, she'd write back, if you think about this, and I go, no. And so we just kept going back, and it has been a joy. And this woman is very, very competent. I knew that before, but I have a greater insight to her working habits and everything else, and I really appreciate her work.
Welcome to my world.
And that is a good world to have her in.
She's a lousy carpenter.
Yeah.
Yeah, well, she did forget the salt.
Oh, no.
Well, you know, on the sidebar on that, Mickey, when I was running Part 4, he always complained about the food anyways. Every meal, didn't matter what I served. So I'm glad to know he's still
Especially
in.
the breakfast.
It's still not only me.
They have worse food in St. Louis, can you believe it?
Of course they do.
Oh my God.
We have one of the best foods going.
No, I wouldn't go that far.
Well, all right. As stated earlier, the board will meet to take a formal and public action on the report, which will conclude the process. Should the board's decision agree with Senator Marty's request, the board would include a date certain by which Dr. Spicer's resignation should be received. Additionally, if there are any recommendations to be made, they will be included in the report. Such recommendations can include, but not limited to, changes in the policies or procedures of both the board, Dr. Spicer's administrative approach. Thus, that concludes the first portion of the process as described earlier. The board hereby considers the record closed. I realize I don't have my jacket on and I'm on the video. Since this special board meeting has no other business before it, I will entertain a motion to adjourn, and thank you.
Motion to adjourn.
Thank you. Do I have a second?
Second.
Non-debatable motion. All in favor, say aye.
Aye.
Opposed, same sign. An abstention. We're adjourned.